Last evening, I joined many of my Senate colleagues at the White House as the President introduced Judge Brett Kavanaugh to serve as Associate Justice of the United States Supreme Court. Judge Kavanaugh is one of the most widely respected judges in the country. I heard the President last night refer to him as a judge's judge. He is an outstanding choice to serve as Justice of the Supreme Court. Justice Kavanaugh, or Judge Kavanaugh, is a former law clerk of the justice that he has been nominated to replace, and that is Justice Kennedy. And I talked about Justice Kennedy's service on the Supreme Court and to the people of this country in my speech yesterday. Judge Kavanaugh earned both his undergraduate and law degrees from Yale University. He then clerked for judges on the Third and Ninth Circuit before joining the chambers as a law clerk for Justice Kennedy. He served in the Office of Solicitor General and also the Office of Independent Counsel. After several years in private practice, Judge Kavanaugh returned to public service, working in the White House counsel's office and as staff secretary for President George W. Bush. In 2006, he was confirmed to the D.C. Circuit, where he has served since. He is also a well-regarded law professor at Harvard and Yale and Georgetown. Judge Kavanaugh is a leader not only in the law, but throughout his community. As examples, he has volunteered at Catholic Charities on a regular basis and coaches his both daughters' youth basketball teams. The committee has received a letter from former law clerks of Judge Kavanaugh, people who represent views across the political and ideological spectrum. Many judges describe their former law clerks as adopted family members. In other words, law clerks know their judges best. So I turned to what some of those said through letters that they sent to our committee. Judge Kavanaugh's former law clerks write that he is a person with immense, quote, strength of character, generosity of spirit, intellectual capacity, and unwavering care for his family, friends, colleagues, and us, his law clerks. End quote of that specific part of the letter. But I want to read a longer quote from that letter. He is unfailingly warm and gracious with his colleagues, no matter how strongly they disagree about a case. And he is well-liked and respected by judges and lawyers across the ideological spectrum as a result. He always makes time for us, his law clerks. He makes it to every wedding, answers every career question, and gives unflinchingly honest advice. That advice often boils down to the same habits that we saw him practice in chambers every day. Shoot straight, be careful and brave, work as hard as you possibly can, and then work a little harder. End a quote from letters from law clerks serving Judge Kavanaugh. His record, his judicial record, is extraordinary. The Supreme Court has adopted his views of law in dozens of cases. Judge Kavanaugh's opinions demonstrate profound respect for the Constitution's separation of powers. He understands that it's Congress's job to pass laws, and where he sits in judicial chambers, it's the role of those people, and he figures it's his role to faithfully apply those laws as Congress intended. That's why his opinions emphasize that judges must focus on the text and apply laws as written by those of us elected to the Congress, not by unelected and in turn largely unaccountable federal judges. And it's meant that they aren't to be accountable except to their Constitution and the laws of this country. Courts may not rewrite laws to suit their policy preferences. Judge Kavanaugh has a record of judicial independence. He's shown a willingness to rein in executive branch agencies when they abuse or exceed their authority. And you don't have to be in Congress very long to understand that that's a daily habit of people in the executive branch of government, to go way beyond or feel your way beyond what the law allows that person or that program to do. As Judge Kavanaugh has explained in numerous opinions, executive branch agencies may not assume more power than Congress has specifically granted them. And he has emphasized that judges may not surrender their duty to interpret laws to executive branch agencies. Now, that's pretty common sense for anybody that's had 8th grade civics, high school government, or political science classes in college. But it isn't something that all judges agree with. The Senate Judiciary Committee will hold a hearing for Judge Kavanaugh's nomination in coming weeks. As I noted in my remarks to this body yesterday, liberal outside groups and Democratic leaders decided weeks ago to block whoever the president nominates. They're already pushing feeble arguments to cause needless delays. For example, some Democrat leaders and Democrats, members of the Senate who aren't leaders, say that we shouldn't confirm a nominee nominated during a midterm election year. Now, where did they get that idea? Because the Senate has never operated like they would suggest. Sitting justices Breyer and Kagan, prominent examples that I can freely give to you, but also numerous of their predecessors were nominated and confirmed in midterm election years. So where do my colleagues get that idea, that just because this is a midterm election year, you can't take up these nominations? Happens that Kagan was approved August 2010 as an example. The American people see this argument then for what it is: obstruction, pure and simple. After all, Democratic leaders announced that they will oppose anyone nominated by President Trump, just anyone. In fact, some Democratic senators announced their opposition to Judge Kavanaugh mere minutes after the president nominated him. It's clear that a number of my Democratic colleagues have chosen the path of obstruction, a path of resistance, not like the Constitution offers every senator to give advice and consent. Here we have a highly qualified nominee who has offered numerous influential judicial opinions. And I stated how they've been respected even when those same cases get to the Supreme Court. We even have leading liberal law professors. Give you an example of Akil Reed Amar endorsed Judge Kavanaugh on the pages of the New York Times. But some of my colleagues can't even bring themselves to at least consider Judge Kavanaugh's nomination. As I mentioned yesterday, liberal outside groups and their allies are trying to convince senators to ask Judge Kavanaugh his views on specific cases and Supreme Court precedent. I want to emphasize that these questions are inappropriate. And in greater detail, I said that yesterday. Justice Ginsburg has announced this famous statement of hers, and she did it during her own confirmation hearing, that a nominee should offer, quote unquote, no hints, no forecasts, no previews, end of quote, of cases that can potentially come before the court. Now, maybe some of my colleagues would think, well, if something's going to come in a couple months after you're on the court, why can't you give us our views of that? But they might be asking questions about something 10 years down the road. So how legitimate are the views? Are you going to overturn this president, or are you going to rule this particular way in a particular case? We also have Justice Kagan declining to state her views on Roe v. Wade, saying, quote, the application of Roe in future cases and even its continued validity are issues likely to come before the court in the future, end of quote. So you expect a justice to look at the facts of a case, look at the law or look at the Constitution, and leave their own personal views out of it, but you expect them to do it independent of anything they've said in their hearing before the Judiciary Committee, because nothing should be said there that's going to influence something 10 years down the road. I expect that Judge Kavanaugh will likewise decline to comment on his views of particular cases decided by the Supreme Court. So I congratulate Judge Kavanaugh on this nomination. I had the opportunity to meet with Judge Kavanaugh earlier today. I know that he looks forward to answering questions from my colleagues in the coming weeks, and I look forward to hearing from him again when he appears before our Senate Judiciary Committee. I yield the floor.